I'm Cheryl. I'm the administrator at CBM Lawyers. I'm here with lawyer Doug Simpson, who is also the leader of our family law practice. Today, we're here to discuss the 5 myths of divorce.
Cheryl, I've been practicing family law for many years, and in that time, I've seen some common beliefs about divorce that just aren't true. I think the more accurate and honest we can be about the realities of divorce, the easier it will be on people to make good decisions as they go through what is often a trying period in their life.
Okay, let's start with number 1. I'm not worried about my divorce because my prenup covers me, or does it?
Unfortunately, that's not always true. A prenup, for those who are unsure, is an agreement drafted and signed by both parties before marriage, outlining one's entitlement to property upon a separation, outlining support obligations, and addressing any other issues the parties consider appropriate to resolve in advance of the marriage. A prenup is a legal document, but the validity of that document depends to a large extent upon the circumstances under which it was prepared. For example, if it was prepared under circumstances in which a valid consent cannot be said to have been given, if there was inadequate disclosure about assets, if the parties have made a mistake about some important factual underpinning of the agreement, if there was no opportunity for a party to vet financial information, or if the arrangements made are unconscionable when viewed against the objectives of the legislation which govern in this area, all of these might be cause to invalidate the prenup. Also, if the agreement contemplated a scenario that didn't play out, let's say the couple assumed they wouldn't have kids, but then they did, or the reverse, that might call into question the enforceability of the prenup, or at least certain aspects of it.
Upon a separation, isn't everything just split 50-50?
Well, as a very general proposition, that's a safe assumption, but it doesn't tell the whole story. You still need to distinguish between family property and excluded property. Family property is split 50-50 in the vast majority of cases. However, the Family Law Act makes allowances for certain categories of property which are considered excluded from division. For example, property that was brought into the relationship, or received as a gift from a third party, or received through an inheritance, or that represents an award of damages as compensation for an injury or loss, excluding lost income, is excluded. That means that, absent some circumstance that might cause one to lose their exclusion, the property remains the separate property of the party to whom it relates. Where there is excluded property present, all that is shared between the parties upon a separation and divorce is any increase in value in the excluded property. Other than excluded property then, everything obtained during the marriage in existence at the time of separation, regardless of the spouse who obtains it, is family property subject to equal division. Further, family property will also include everything obtained after separation by a spouse, which is derived from family property, as well as the aforementioned increases in value to excluded property, unless the parties have an enforceable prenup which divides assets differently. Incidentally, the same holds true for debts. Debts incurred by either spouse during their relationship or after they have separated, if for the purpose of maintaining family property, is a joint responsibility of each spouse.
In a divorce, the man has to pay for everything.
Again, not true. Determining an entitlement to spousal support is often a complex thing to assess, but it has nothing to do with the antiquated notion that it is always to be paid by the husband. At a minimum, a spouse making more money is the one you would likely look at as being required to pay spousal support. However, it is based upon many factors which vary from case to case, and a mere disparity in income is not sufficient in and of itself. In order to understand one's entitlement to spousal support, or liability to pay spousal support, it is best to schedule a meeting with one of our family lawyers to get some legal advice unique to your situation. Child support is more straightforward than spousal support, but like spousal support, it is not always the case that it is paid by the husband. Basically, both parents have an obligation to support their child. However, the courts will impose a specific financial obligation upon the parent with whom the child does not primarily reside, which is based upon that parent's income. When that parent starts to have the child in his or her care for at least 40% of the time, then the court will consider the parenting arrangements to be shared, and will then take into consideration the income of the other parent, which may then result in a reduction in the amount of child support to be paid. It is important to remember that child support also includes certain expenses that may be considered special or extraordinary in nature, such that it would not be reasonable to expect one parent to solely pay the expense without a contribution from the other. Common examples are braces or childcare.
Another cliche that suggests, if my husband cheated, then I get it all, don't I?
I'm reminded of Ivana Trump, who said, "Don't get mad, get everything." Well, she didn't live in BC at the time. Here we have no-fault divorce. That means that under our Divorce Act, the conduct of either party is not relevant to division of assets in a separation or divorce. So the courts don't care who said what to whom, or what someone's spending habits have been over the years, or whether the breakdown of the relationship is due to one spouse having an affair. Other than some very narrowly defined circumstances where a spouse's behavior may have resulted in debts not incurred in the normal course of a party's relationship, or if a spouse may have acted in bad faith and caused a substantial reduction in the value of an asset or its outright loss, and then only if it would be significantly unfair to equally divide the assets. In almost every case, assets are going to be equally divided, notwithstanding poor behavior on the part of a spouse. Of course, conduct may be relevant when it comes to parenting arrangements, as we discussed earlier.
And that takes us to myth number 5, that spousal support ends when someone gets remarried.
Again, not true. Remarriage of the party paying support does not automatically end that person's responsibilities to their previous partner, nor does marriage of the person receiving support necessarily impact their continued support payments. This is especially true when support has been awarded on compensatory grounds. In that case, support is compensation for financial loss caused by the relationship and its end, career loss, loss of pension, etc. So the support obligations won't end until the party has been fully compensated, remarriage or not. An event such as a marriage may give grounds to revisit the support obligation, and the result of that may be that the support is reduced and the duration limited, but that is not guaranteed in every case.
What should someone do if they have any questions or concerns about these myths or anything to do with prenups, separations, divorce, or co-parenting issues?
Well, they can certainly feel free to give me a call or anyone in our family law group. We're always happy to help, whether it's just answering their questions to help them make a more informed decision, or if they've decided to take a step and need someone to represent their interests as they prosecute their claims.
Thanks, Doug. For more information on this and other family law issues, or to learn more about our family law practice, go to www.cbmlawyers.com.